since Monday.
Good morning. Today is Monday, September 9th. And I logged in a little early today. My cases don't start until 9 o'clock. I have some civil pretrials and civil motions starting at 9. I got a text from Judge Pattison at about 6 o'clock this morning advising that he wasn't feeling well and he wouldn't be in today. So I've got his docket and my docket. So I have the Monday morning criminal arraignments. Jeanette Jackson is here with me from the public defender's office. And so far we don't have any customers. Started the morning with some technical difficulties. Had to work through that. So it's been a little hectic this morning. We're gonna start our misdemeanor arraignments. Pre-trials. He also has a couple of probation violation arraignments that I'm going to have to quickly familiarize myself with. His afternoon docket is domestic relations, and I won't be covering that. Those cases will just be adjourned. So we're going to have a busy day today, and I guess that's good. We had a nice enough weekend in Michigan. I hope your team won. The Lions won in overtime last night. But if you're from Michigan, you're used to having your heart broken by the Lions. But we'll see. They might be for real. Michigan State won. Michigan did not. Other varying scores around the country. So, Ms. Jackson's out trying to round up some clients for me. I'm going to have to take a look at these probation violations that are set for 9. Actually, I have 3 of them. I went to my great niece's wedding reception on Saturday. Very nice. Said I would say hello to Mr. Jamrock from Colon. Good morning to you, sir. My niece is the prettiest girl in Sherwood, to be determined. If you don't know where Sherwood is, well, you're in good company. Anyway, I'm just here waiting for some clients. No, you can go from national champion undefeated to, and also ran in a very short time. Good morning to Scotland. Sorry about Maryland and Michigan State for you Maryland fans. All right, I got up a half an hour late. Rather than 5:10, I got up at 5:40, and I got that message and realized I should have got up earlier. Also, we'll be covering Judge Pattison's bench warrant arraignments. The jail population was at 97 this morning, which is good. A few people got arrested over the weekend. Yeah, that's awfully early. No bike ride this morning. No morning swim either. Enough steam is coming off the water, meaning it's giving up its heat. I mentioned this last week. Someone brought me their 1 year AA coin, and the same person gave me a 3-year coin. And I have a collection of these. I always appreciate people that are maintaining their sobriety. Well, I'm just letting this run, but I hope to have some work to do because I've got my own work to do at 9 o'clock. 1, 2, 3, 4, 5, 6 arraignments, 3 probation violation arraignments. No, I have not read any books by Quentin Jardine. I hear some voices out there. Attorney Rognus is not here. He has made some plea offers, which are pretty generous. Scratched out on a piece of paper. I don't remember what book I was talking about. There was a book, I think I mentioned it before, that was written about the way we handled criminal sexual conduct cases when I was in the prosecuting attorney's office. It's called Seeking Justice. It was written by a professor and a group of people from University of Michigan and Michigan State. They gave everybody alias names. My name at one point was Kravis Navarre, and then I don't know what my name was in the book, but it talked about how we developed a protocol to investigate and prosecute criminal sexual conduct cases. Many of the people that were in the book are no longer with us, and everybody but me is retired. And that system that was once in place is long gone, but it did work very well when we were doing it. Seeking Justice by Kathleen Fowler. It's available on Amazon, but it's expensive, like $70. I'm not sure where they got Kravis Navarre. One of the authors was from Navarre, Florida, or had a winter place there, and there's the Kravis Center. not as cool as Travis McGee, but anyway, all right, here we are once again with the world's most boringest live stream. I turned everything on to be ready to go right at 8:30. It's 8:21. I've yet to see a customer. We also have a couple of pre-trials this morning. This would have all been Judge P's headache. Letting this run longer than usual because we don't have anything going on, but I do appreciate everyone who says hello in the morning. Good morning.
Good morning.
You haven't been in, if this is the fanciest courtroom you've seen, you haven't been in very many courtrooms. This one is pretty basic.
Oh, she's negotiating in the end. This is pretty basic too.
All right. Well, this was early 1970 construction. Let's see who we've got. Good morning, Mr. Fuller.
How you doing? Good morning.
You aren't set for anything today. You just here with somebody else?
Yes, sir.
All right.
Ours says courtroom D.
Yes,
Yeah.
Judge Pattison isn't here this morning, so you're stuck with me. I'm Judge Middleton. Let's see who's here. Which case are you guys here on? What's your
my
name?
name?
Yeah.
Mateo.
All right. I believe we only have one that's not here so far. All right. No Jackson. And which case are you folks here on?
Scarberry.
All right, Kelly Scarberry. And Mr. Fuller came just because he wanted to get up early and come to court this morning.
Yeah.
Hope your team won this weekend. All right, I guess we're ready to go. And so we do have some customers. Let's get started. So thank you all for saying hello. Hello to the shut-ins in South Bend. And all early risers in California. Ms. Jackson is gathering things up. Let's see who we got. Since Michelle is still off, she told Tyler to take good care of me, so.
No promises.
Deputy Tyler is here to help me stay on track. Let's start with Mateo Jackson. Mr. Jackson, would you come up to the podium? We start the recording. As I mentioned, we had difficulty with our system this morning. We're on. First case is People versus Mateo Javier Martinez Jackson. That's you, sir?
Yes, sir.
You got a ticket for operating with a suspended license. We get lots of those here in Michigan. It's a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. Prosecuting attorney Andrew Rognus had reviewed the files this morning and made some offers. This charge, as I mentioned, is punishable by up to 93 days in jail and a fine of up to $500. It also requires that your driver's license be suspended. prosecutor, Mr. Rognus, looked at this, and he agreed to dismiss the driving suspended charge if you plead to a charge of allowing another to violate the motor vehicle code. Now, you're from Indiana. This may all sound a bit foreign to you, but this charge, allowing another to violate the motor vehicle code, is under 257 326 of the Michigan Motor Vehicle Code. It doesn't go on your driving record. It won't prohibit you from trying to continue to get your license. It doesn't carry any points, and it doesn't carry a suspension.
Does it affect the other individual in the car?
No.
Okay.
Why, did they get a ticket too?
No, I'm just, if
No.
it did, I wasn't
No.
gonna take it.
Allowing another to violate the motor vehicle code is actually a legal fiction. The other you're allowing is yourself. But the prosecutors use it to help people keep from getting their license further suspended.
Right.
Are you willing to plead to that lesser charge of allowing another to violate the motor vehicle code?
What's the punishment carried up?
You're
with
gonna
it?
get a $225 fine, and I'm gonna give you time to pay it.
It would be just a fine?
Yes.
I'll plead guilty.
All right, other than that, did anyone threaten you to get you to plead to this?
No, sir.
Or promise you anything?
No,
Other
sir.
than what I just said?
No, sir.
9-9. I'll move too fast.
You're doing just fine.
Thanks for that vote of confidence. It is Monday, and we started out in a bit of panic mode when we found Judge Pattison wasn't going to be here.
That's all right. I looked up the GPS and it said Centerville, and I looked up the wrong Centerville, and I thought I was gonna have to drive 4 hours away from home.
Where's the other Centerville?
It's up by Traverse City or something like that. It's up by the Mackinac Bridge.
Yeah, he was really confused.
Yeah, I was like, I'm not going to that.
Well, there's a center line, which is a little 1 square mile village in the middle of,
I'm not sure. The GPS might have been confused.
I think it was. All right, well, anyway, you signed this advice of rights, meaning you're giving up the right to have a trial. You understand there will be no trial?
Yes, sir.
All right, well, let's take a look at this. You were driving at 6:31 p.m. US 131 in Youngs Prairie Road. You were also got a warning for speeding, which isn't exactly terrible. 60 and a 55. 60 and a 55. Anyway, we've all done that.
The cop was nice though. He let it. He dismissed it.
No, you were actually going 71. So they would notice that. Yeah, he's a trooper.
Yeah, he was nice about it.
All right, anyway, you're gonna end up with one charge of allowing another to violate the motor vehicle code. It doesn't carry any points and it doesn't require a restriction. Where were you going?
We were on our way home from visiting her aunt.
Where did she live?
You can pull up the address from. I don't know exactly where it was
It's
at.
Battle Creek.
All right, you're not real good at your Michigan geography.
I'm not from up here, no.
All right, and is your license suspended down in Indiana?
Yeah, apparently so. I didn't know that before.
Let's take a look.
That's what he told me at least.
Yeah, you're gonna have to go down there and figure it
Okay.
out in Elkhart County.
Could you tell me what the reason for suspension
I
is?
can't tell.
No? Okay. That's fine.
They ran it in Michigan. Well, wait a minute. Learner permit. Yeah, nice picture. Did you have a Michigan license at one time?
No, sir.
You have, it says suspended infraction OLN. Not sure what that means.
Neither do I.
Well, you gotta go to Elkhart.
I'll take care of that.
All right, anyway, the fine's $100. You do have a driver here today. There's a $75 crime victims' rights fee and a $50 state minimum fee. In Michigan, every offense carries $125 of state costs because the state thinks everybody is rich. Fine is $100 and the rest of it is state costs, $225. Do you need some time to pay that?
Just like 2 weeks if that'd be
Well,
all right.
we usually do at least 30 days, so let's go till October 11th.
Perfect.
I'm gonna give you an envelope. You can mail in a certified check or money order. You can come in with green cash. I don't suggest mailing cash. Or you pay online using a credit card. There's instructions in here.
Okay.
Inside is $225, 10/11 is the date.
Probably just pay it online.
Yeah, that's the easiest way. All right, you're good to go, sir.
Okay.
That
Are we
won't
done?
affect your record, but you're gonna need to get squared away with Indiana. Don't get another one of these because it gets really expensive.
Yes, sir.
All right, you're good to go.
All right. Thank you very much.
Apparently he hasn't been to a lot of courts. We get a lot of people for reasons I just am humbled by that come here to visit. I think they're greatly underwhelmed when they get here. It's just a little square round room with no windows in it. So I don't know what other courtrooms we were in, but this one's apparently nicer than that. Is Shantel Goodman here? Good morning.
Good morning.
Good morning.
Morning.
You're Shantel Marie Goodman?
Yes.
You got a ticket for driving with no insurance. You get lots of those. In fact, I mentioned last week that the police now can run your plate and tell whether your car is insured or not. They didn't used to be able to do that. And Deputy Hunky, who was a Three Rivers police officer for about 38 years, gave me the details, further details about it. But so no insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500, not less than $200. So the minimum fine for this is $325. Because it's punishable by up to a year in jail, it also requires that you get fingerprinted. And we see these every single day. Attorney Rognus, who's working for the prosecuting attorney's office, reviewed this, and he would agree to dismiss that charge for a plea to no proof of insurance. Do you have insurance on the car now?
Yes.
All right, tell me about that.
I got it on Friday. Insurance for it.
Very good. Did the car get towed?
No.
Well, you're fortunate.
Yes.
That can add another $300 to $800 on the cost of this. Which company did you get your insurance from?
Look Insurance. It was online.
All right, having no insurance is a misdemeanor. As I said, it's punishable by up to a year in jail. No one ever goes to jail for a year for this, but it does carry a hefty minimum fine. There is a lesser charge known as no proof of insurance. That means you didn't have the little slip in the car. That isn't even a crime. It's a civil infraction, like a speeding ticket. And the fine for that is $150. It's not a misdemeanor, it's a civil infraction. So Mr. Rognus said if she has insurance, I'll reduce it to no proof of insurance. I'll give you a fine. You'll have time to pay the fine, at least 30 days. You understand?
Yes.
Are you willing to do that?
Yes, sir.
-2, 4. 1. Where were you going?
I was heading home. I was picking up friends they were fishing at the dam.
Picking up who?
A couple friends who were fishing at the dam.
Which dam?
The 8th Street dam in Three Rivers.
Oh, out there.
Yeah.
I've been seeing a lot of people fishing off bridges this week. All right. You have insurance now. Where'd you go to school?
I graduated from Sturgis.
Sturgis. You're about the same age as one of my kids. I don't remember you from there, so that's why you were at a different school. All right. Fine is $150. And it is due within 30 days. We'll call that October 11th. Here I go again. Same thing. I'm going to give you an envelope. You can pay in cash. You can pay online. The instructions are in here. And this is a civil infraction. Doesn't carry any points. Doesn't require a restriction. Will show up on your driving record. But it's like a minor speeding ticket. So the goal is to have people get insured. You can use that envelope to pay the fine. You're free to go.
Thank you.
Get Duran mixed up, but I think that was Karan for here with her. All right, let's keep plugging away here. Mr. Kevin Scarberry. Morning, sir.
Morning.
Rob's secretary did a breakdown of who owed us money this morning. So I don't know where it is. So I have to look. Anyway, this is file 241256ST, Kevin Wade Scarberry. Also charged with driving suspended. Similar to the very first case, punishable by up to 93 days in jail and a fine of up to $500. He also is an Indiana driver. He also was going too fast. Same officer, Trooper Abdullah. Same place. They sit out there. Well, this is
I was coming down the hill before the lane split into 4 lanes.
yeah. And anyway, you have the same offer, allowing another to violate the motor vehicle code. The one that carries no points, no driver responsibility fee, and doesn't get abstracted to your license. I think the speeding charge got defaulted, but this would dismiss the driving suspended case, and your fine would be you were going 77. Coming down the hill, I guess that's easy to do. Anyway, this would result in a fine, just like the first gentleman, of $225. It would not go on your driving record. and your issues are in Indiana, you're gonna need to get those straightened out. Are you willing to plead to that lesser charge of allowing another to violate the motor vehicle code?
Yes. Yes.
All right, anybody threaten you to get you to do that?
No.
Where were you going?
The casino.
Which one?
Battle Creek. Firekeepers.
All right, you were northbound?
I was heading north, 131.
Well, you must have been in a hurry to get there because all right, hope you won $225 to pay this ticket. Do you know why you're suspended in Indiana?
I got a couple unpaid tickets there.
All right. Well, they used to suspend you in Michigan for unpaid tickets, which frankly I agree with, but the legislature changed that. Anyway, this isn't going to go on your record. It shouldn't affect your ability to get squared away in Indiana. And you understand you're giving up all the rights here on your advice of rights, and there won't be a trial.
Yes, sir.
All right. What do you do, sir?
Unemployed right now.
All right. Do you need some more time to pay this?
Just 30 days.
All right, that'll be enough. We'll make it due by October 11th. Now, there may also be a speeding ticket lurking in there. You failed to appear for your arraignment, and Judge Pattison issued a bench warrant, but then it got recalled. 2, 2, 5, 10, 11. I'd recommend before you leave, you go out to the counter out here and check with the ladies about that speeding ticket and see if that's out there also. All right. Anyway, this won't affect your driving record. If the speeding is on there, that will. But good luck. You have a driver with you today. That's good. You're good to go.
All right, thank you.
All right, we're moving along. What? It can all go out so far. Oh, wait a minute. This is Mr. Scarberry's paperwork. Laura did a cheat sheet, but I don't know where it is. You probably did, but I have so much stuff. All right, let's see who else is here. Kathleen Miller, would you come forward, please? Why don't you have a seat, ma'am? You'll be more comfortable.
Thank you.
All right, this is a bit of an unusual citation.
It was an unusual situation.
You got a ticket for possession of captive wildlife.
It was a baby fawn.
Baby fawn, all right. I'm not even sure. Let's see what the plea is for this. There is no plea offer here. It's plea as charged. It's a DNR violation. I'm not sure. The DNR's got some substantial fines. Yes. A minimum fine of $50, maximum fine of $500, 90 days maximum jail. The assessed penalty would be in that range. However, there's a reimbursement for deer that goes to the DNR, so the fine would be $1,275. I can't tell anything about this or how. There's no police report, just this ticket. Possession of wild fawn, captive wildlife. That's all I know about it. But it carries a $275 fine plus $1,000. The DNR has got some substantial financial penalties. My colleagues in Detroit don't deal with these. My colleagues in the Upper Peninsula deal with them all the time. Anyway, Miss Miller, what's your thought here? Would you like to get some help or have me set this for a further pretrial?
I'm not guilty.
All right. I think I can ask this, Miss Jackson. Where is the fawn now?
They have it.
Okay.
Yeah, it was, they came and got it. And
All right.
it was put into like a dog pound truck. And I don't know where they took it.
All right. So the DNR took the fawn. How are you involved in this?
She's
I
my witness.
tried to help her to get a place for them to come and get the deer.
All right.
And I seen with my own eyes, out on their property, there's usually deer out there.
There's
and
a
she
field right
tried-
next to our.
All right. Well, don't tell me more about it at this point.
It would have got killed.
I'm gonna set this for a pretrial with. I think this ought to be able to be resolved. Set a pretrial for this is the 9th. Wednesday, October 18, excuse me, September 18. I keep doing that. 2024. I'm going to have you come back in and meet with the assistant prosecutor, explain the circumstance. He's not here on Mondays. The prosecutor is essentially down to 2 people. They've got 2 contract employees that are helping with some things. One of them is Mr. Rognus. He probably has a police report. All I have is a ticket. This is Fair Week when I'm having you come back in. Wednesday morning at 8:30, courtroom D for a pretrial conference. Check in at the court office. You're welcome to come back with her and help explain it. I'm sorry I have to ask you to come back, but I don't have a prosecutor here today. And I don't know that I have the authority to waive that $1,000 DNR cost. So we'll reset this. You can explain it. They can decide what they want to do. I'm sure your goal wasn't to harm this fawn, but the DNR's got some strong statutes. All right, you're free to go. $1,000. Well, we're doing all right. My case will start at 9. I got 10 minutes. Let's see who else is still here. Do I have William Rose? Is Sir, that's the attorney's side. Why don't you sit over here? William Rose. All right. Bosh. Harley Davidson Kinsey. Charged with driving suspended. Davidson Kinsey. There are a lot of people named Harley for that reason. Bronson is not here. Trying to order to show cause first. There's no phone number. Well, I'm out of files, so let's see who else is here. I have 3 probation violation arraignments, and maybe they're here. Not very familiar with these. John, I'm just taking roll. John Kettlehut, Destiny Leadford, Erica McNair. All right, let's take that one. What's your name, sir?
Graver, Dennis Graver.
Did you just have a pretrial?
I had a ticket. I'm just in here to plot that back. So.
Oh, okay. Well, good morning, Mr. Graver. If there's anything we could take care of, well, I'm willing to do it while you're here, but it's a public courtroom and you're certainly welcome. All right, Miss McNair, good morning.
Good morning.
Why don't you have a seat? This might take me a minute. I don't believe Miss Kiefer, your probation agent, is here. I'm covering for Judge Pattison. As we indicated, he's not feeling well today. Where are you from originally, Miss McNair?
Chicago.
I know a lot of McNairs from Three Rivers, but I'm not sure.
They're my kin folks also.
Are they? Okay.
I think you had my uncle a few times. He had Larry McNair, but he passed away last year.
Yes, he did. Always interested in reading the obituaries, some of the black families in Three Rivers. There's a lot of connections between families, old line families in Three Rivers. Everybody's related to everybody else. But let's talk about your case. You were convicted of impaired driving, put on probation by Judge Pattison in December of 2023. Your probation agent, Autumn Kiefer, is recommending a probation violation, alleging that you failed to abstain from the use of alcohol or drugs, failed to take your tests as demanded, and failed to complete your community service work hours. She's recommending 5 days in jail. Here's Autumn now. This is what's called a probation violation arraignment. At your original hearing, you had Melissa Halleck as your lawyer. Then she came to the prosecutor's office, and then you may know she was killed in a traffic accident. She was killed on the way to work. Yes, your lawyer. It was a terrible thing, and we're still reeling from it. We're gonna do some sort of a eulogy here this fall for her over at the new courthouse. At any rate, Miss McNair, my suggestion would be that you get an attorney to help you with this. I think Autumn is here with us now. Autumn, I'm covering for Judge P this morning. When did you last have contact with Miss McNair?
On a report day, she reports on a regular basis. I've never had no contact with her, so she's good. She just reported end of last month.
All right, so she's on top of that.
Yes.
All right, I'm gonna recommend that you plead not guilty. Set a PV arraignment, PV hearing, and appoint an attorney. And Autumn, I just had a hot minute to look at these cases. So she's in compliance now and she's testing it and back on track, or is she still?
No, she's continuing to test positive for alcohol, but she is apparently beginning treatment. We'll see. But she is reporting as she's supposed to.
All right, Miss McNair, this isn't easy. You tell people, don't drink, don't use drugs, don't use methamphetamine, don't take opioids. Like, if you could quit, you just would. Everybody would. It's hard, and so this is December. Now we're all the way to September. We need some treatment in here. And one of the ways to ensure that people are not continuing to drink is by testing. So I'm not sure exactly where this is headed. She has recommended a jail sentence. You have a right to have a hearing on this where it must be established, at least beyond a preponderance, that you violated the terms of your probation. Even if you are found to have violated it, the decision for sentencing is up to the judge. So some of it depends on how you do between now and then. So at this point, I'm going to take you out, appoint an attorney for you, and we'll set a probation violation hearing. But I think you should have a lawyer to help you with this. It won't be Ms. Halleck, but we'll get another attorney for you. Okay, you're good to go.
Thank you, Your Honor.
Thank you. Now, Autumn, I also have Destiny Leadford and John Kettlehut, who are Judge P's. And,
Mr. Kettlehut is on with Matt.
All right.
Both of those, Leadford and Kettlehut, are both on with Matt. Matt is still off this week.
All right.
Do you need me to sit in?
No, you're good. I know you got your hands full down there. Being at least one short. When we lose Priscilla, we'll be even more short. Plus, aren't you magistrate today?
Yes.
How do we do? Do I have people I need to see?
You have one, I have three.
All right. Thanks for your help. I know you're busy, so in fact, at this point, neither of the people are even here, so.
Okay.
All right, you're good to go.
Thank you.
All right, Miss Jackson, that's all I got. Kind of uneventful. I'm about to shift gears. Thanks for visiting, sir. All right. Had a local visitor. We had a nice lady from New Jersey last week that I barely got to talk to.
I did send an email, so we do have 2 in custody for violation of bond conditions. We've been in correspondence with Thompson and Rhonda Ice because they're the attorneys on the files. What time works out for you?
Right now, well, I got Jeanette.
Okay, I will give them a call. I will bring your Polycom in. Do you want the violations now?
Who's the Polycom?
I'm trying to think. Fitch, I believe. Sam Fitch.
Yes, he had a gun and a bunch of stuff. Well, Jeremy, we still going here. Let me stop this record. Jeanette, I'd ask your indulgence to stick with me. It looks like I got some other stuff to do.
My wife.
You're making the big bucks, so you might as well stay.
Oh,
All right.
no.
All right, it says misdemeanor arraignments, but we're gonna segue into pretrials. Good morning, Mr. Hintz.
Good morning, Your Honor. How are you doing?
I'm doing okay. I got extra docket this morning. The other judge isn't here, so I've been covering criminal matters. But it seemed to work out. Okay. Now we're ready for some civil matters. And I didn't have enough to do, so Shayna brought me some more stuff. It is 9 a.m., 9:01. Your case, I haven't seen you represent this client before, but it's Havenwyck Hospital versus Suzanne Groff.
Yes, that's correct, Your Honor.
And the claim is for $2,072.70. Havenwyck Hospital. Where is that?
I think it's, I want to say over a little bit further east of you and me, Your Honor. I want to say kind of in the southwest side of the state.
Well, the address isn't on here. Anyway, it's a claim, as I mentioned, for $2,402.32 when we add in costs. The defendant filed an answer. Jennifer Payon is joining us. She sometimes represents defendants, but she's on our next case, Jean Spar. Anyway, you saw her letter.
Yes.
I was unable to obtain a job. I'm trying to catch up on my mortgage, student loan, vehicle payments. All my credit cards and other hospital bills have been sent to collection, so she's in some financial distress. She is not here. I do have a default judgment in here. Let's go through that.
Yes, Your Honor. I did locate, my client is located in Auburn Hills, Your Honor.
Oh, okay.
And as you've correctly stated, she was served, did file an answer, and I think it seems to indicate more of an inability to pay rather than disagreement about the balance. And
I would agree.
And the balance, like you indicated, was $2,072.70. There was statutory interest added in the amount of $127.49. This was a bill that the defendant was responsible for, as the patient at the time was her child. And with that in mind, Your Honor, there was personal, like I indicated, personal service.
Let me check and see if she's here. We're looking for Suzanne Groff. Do we have any civil clients out there? Yes. All right, thanks. I don't know if she's here. I'm sorry to interrupt you.
No, Your Honor.
You indicated the interest, the attorney fees, and the other costs gives us a total judgment of $2,402.32. Is that what you hit?
Yep, that's correct, Your Honor. $2,402.32. That's court costs. That's everything.
I do have a default judgment here. I think she's struggling with this and other bills, as many people are. She can put this in the mix.
Your Honor, we do have a phone number. I've tried to call once, and I'll try and get a hold of her again. Maybe we can work something out. You know, that's usually what we always try to do. It's the most
direct. Yes, we often
way.
Work that out, but it looks like she has a number of other debts too.
Yeah.
All right, default 240232. She is not here at the courthouse. She's 6 minutes late. If she shows up, I'll send you an emergency email contact to rejoin us, but it looks like she's not going to be here. So, thank you. Have a good Monday. Mine started out a little busier than I expected, but sometimes that happens.
I hope it gets easier, Your Honor.
All right, she's not here. All right, thank you.
Have a good day, sir.
Thank you.
Thank you.
Good morning.
Good morning.
This is LVNV Funding, LLC versus Jeannie Spar, S-P-A-H-R. LVNV Funding is represented by Stinger and Stinger. The defendant is represented by attorney Jennifer Payon, except you told me how to say it, and I'm not saying it right.
That's okay, Your Honor. I appreciate the effort.
Well, you say it.
Payon is correct.
And as I said last time, your ancestors said Payon, but Paylon, P-A-I-L-L-O-N. I have before me, Attorney Paylon, an order for conditional dismissal signed by you and Preston Nate from Stinger and Stinger, resolving this matter in the amount of $2,055.80. So I'm assuming I can simply enter that order and that will resolve this matter?
So we had signed that, and then I immediately had let them know that my client was unable to do it, and so I wanted to rescind that. So I don't know if maybe there was an accident with it submitted. So I apologize for that. That would be on our end for any miscommunication there, but it was actually last hearing we were signing it, and then I got word from my client that her bank account had been compromised, and so she was unable to go forward with it at that time. So we rescinded it immediately. So I don't
know if I got word that it was rescinded, and I don't know whether Stinger and Stinger got that notice.
Yeah, that's what I'm worried about right now.
All right, so let me indicate I have not signed it yet. I wait generally till the time of the hearing before I do sign them, in case something like this happens. Otherwise, we'd be having a motion to set aside the conditional dismissal. So the stipulation was not entered. Plaintiff failed to appear. Because they thought the case was settled.
Yeah, I'm sorry. That is a little bit of a mess, Your Honor.
That's all right. Judge Welty, who was one of my predecessors here, I came from the prosecutor's office for 23 years, and I did all criminal prosecution cases. So my first day as district court judge, Judge Welty said, since you were a prosecutor, we're going to give you all of the civil cases.
Why not?
And he said, don't worry, if there's a mistake made, it's easily to undo it. And so unlike a criminal case, if you accidentally put somebody in jail, that's hard to undo it. So it's just money, and if there's an issue, it can just be redone.
I appreciate you ending, and I don't envy you on your prosecutor side. That is tough work. I do
it
some
is tough work.
There's editing stuff for Westlaw, and I've been on criminal case rotation for a while, and ooh man, I don't think I could I could stomach that on the daily. So,
Well, the hardest thing was child criminal sexual conduct cases, but I did lots of them. All right, well, anyway, let's just set this for a new pretrial.
Okay.
Conditional order not entered. And actually, that was the best job I ever had. And we'll reset it. We'll have the clerks find a place to put it, and we'll try it again on a Monday morning in a couple of weeks.
Thank you, and I appreciate your patience.
All right, I'll see you then. Thank you.
Take care.
All right, Jeanette, let me dial up some of our 3 new customers here. That takes care of 2 of our civil cases. We got Samuel Fitch on an operating while intoxicated. What's this one about? Failed to appear for attorney pretrial. His lawyer is Luke. Bradley Cade, violation of bond conditions. Larry Barnes, violation of bond conditions. We'll probably just bump both of those to tomorrow. So let me stop the record. I got more civil at 9:30. Good morning, booking office. Judge Middleton calling. I got a couple customers I need to see. Jeanette Jackson would like to know if I could see Samuel Fitch. Then I need to see Bradley Cade and Larry D. Barnes. Yep. All right, thanks. Bye. Bye. Good morning once again, everyone. We've got more to do. We're going to try to get some things done before we do our next civil cases. I'm going to shut that chat off. But thank you for saying good morning. Take 17 steps to shut the chat off. Good morning, sir. Are you Samuel Joseph Fitch?
Yes, sir.
I'm Judge Middleton. I'm here on behalf of Judge Pattison, who's not here today. So I'm covered for him. We need to get your case on track here. Also here with me is one of the public defenders, Jeanette Jackson. Your lawyer, Mr. Luke Nofsinger, was not available on very short notice. You got arrested over the weekend on several things. This is the operating while intoxicated. It's file 24265SD. You were arrested last December, or the incident was last December. They issued a complaint in February of 2024 with operating while intoxicated. You pled not guilty, and we set several pretrials. You were here in April and you left, and then they reset the pretrial for April 22nd. And you didn't show up. And Judge Pattison issued a bench warrant for failing to appear.
I told him I couldn't make it because I was homeless and I didn't have a ride.
All right, well, we're here all day, every day. There was a 48-hour hold. Anyway, we'll get the case back on track.
Okay.
How'd you come to get arrested this weekend? I see you have some other charges.
They come to my house and got me.
All right. Well, where were you living?
I live with my mother in the backyard.
Where's that?
3 Rivers on South Lincoln.
Is your mother Alona?
Yes, sir.
I knew your dad years
He passed
ago.
away.
I know he did. I knew your grandma and grandpa too, but he used to date my sister, and point of fact, she's passed away too. All right, defendant arrested at his house. That was April, it's now September. You never bothered to call your lawyer or come in here.
I've been homeless and phoneless.
Okay.
I'm going through a divorce, and I'm living on the streets.
Okay. Well, there's plenty of jobs out there.
Yeah. Well, I
All
gotta
right.
get my. But
The good news is Judge P will be here this Friday for next Friday. Look at this. September 20th. Set attorney pretrial for 9/20/24 at 8:30. Your attorney is Luke Knopfinger. Now, you got new charges that the magistrate is going to see you on: felon in possession of a firearm, reckless use of a firearm, possession of methamphetamine, which is really why you haven't been showing up for court. So you'll get arraigned on those a little later this afternoon by the magistrate.
I have a
bond.
question.
Okay.
I've been going to the hospital. I had to go to psychiatric ward, and they told me that if I keep doing what I'm supposed to be doing, them charges were going to be dropped.
Who told you that?
The magistrate, when I talked to her. I talked to a magistrate when I was in the hospital.
Don't know the answer to that, but we'll sort it out. We'll get an attorney for you and set a hearing on that. All right.
Okay.
Anyway, she'll see you this afternoon. It's not up to the magistrate to drop the charges. That's up to the prosecutor. So I don't think she told
the prosecutor. I talked to a prosecutor when I was in the hospital.
All right. I don't know a thing about it, but we'll sort it out. All right.
Okay.
You're good to go. Good morning, Mr. Varchetti.
Good morning, Judge. How are you?
I'm good. I've got a lot going on. I'm doing double duty. The other judge was ill today, so I'm going to take care of a couple criminal matters. Your case isn't up for 4 minutes, so let's deal with Destiny Hope Leadford. Please come up to the podium. This is file number 23807SM, Destiny Leadford. Miss Leadford was placed on probation on a charge of domestic assault. The probation officer, Matt Huff, filed a probation violation petition alleging that you failed to report on a monthly basis and you failed to abstain from the use of drugs and alcohol or test on demand. He's recommending that your probation be revoked and you get 60 days in jail. You fell off the map. We haven't seen you since April, but you are here, so that's a positive. You need some help from an attorney, Miss Leadford. You're facing potentially 60 days in jail. This is Judge Patterson's case, and he's not here.
I have since then gotten a job, and I'm just trying to get things right back on track.
Well, I'm all in favor of that. But right now, I'm going to show you're pleading not guilty to the probation violation. Right now, it's just an allegation. The prosecutor would have an obligation to prove beyond a preponderance that you violated that probation before you could be found guilty. And you'd have a right to have a hearing on that allegation, and you have a right to have an attorney. Mr. Huff isn't here. I would have you go down and see him. Are you still at Laura Drive, apartment A?
Yes.
How come you haven't seen your PO since April?
I've just been going through a lot, and then getting right up here, it feels like I've just had my hands tied, and I kind of just like swept it behind me and tried to things back in line.
Where's your new job?
Wendy's.
In Sturgis?
Yeah.
I'm going to set a PV hearing. I'm going to send you out to the counter, and they're going to appoint an attorney for you and give you a hearing date. Then I'd like you to go downstairs and at least check in with the clerk about where you're doing and what's been going on. And she just avoided this. All right, I told the last lady, that's a recommendation. It's not cast in stone. This hearing will be before Judge Patterson. He knows more about this than I do. But you're here, which is a good thing. You got to see the new courthouse in Three Rivers. However, I don't know who told you to go there, but...
I just got confused.
All right, well, you're here now, and you called us, and they called ahead and said you were on your way. So the good news is there's no bench warrant. The bad news is you're off the grid and have been since April. We need to get back on track.
Absolutely.
So you go out to the counter, we'll appoint a lawyer and give you a hearing date. Then I want you to go down to the probation department, check in with the clerk, and they'll get some updated information. Who? All right, then just go. No, Autumn's got her hands full. You go out there, they'll give you your attorney, call your attorney, make an appointment to discuss it with them.
Thank you so much.
All right, Judge P, we'll see you now. Someone is here, Mr. Varchetti, has iPhone 6, so let's see who this is. I've got several plates spinning. Mr. Cade, good morning. I'll be with you in just a moment.
Good morning.
I've got someone who's logged in as iPhone 6. Good morning. Are you Karina Blanco? Good morning. Are you Karina Blanco?
Yes.
Let me give you a proper name here. All right, let's talk about your case. Mr. Cade, I'll be with you in just a moment. This is a big fat file for what it is. This is file 24265GC, which stands for General Civil. LVNV Funding versus Katrina Blanco. It is a claim for $1,294.91. The esteemed Mr. Paul Varchetti is here on behalf of LVNV Funding, and you are here. This is also set on the hearing for summary disposition. They filed this claim. You filed an answer. I'll just read it. I've been calling LVNV Funding for the past few weeks to try and get on a payment plan. Unfortunately, I've been given the runaround, or I keep getting hung up on. I just recently moved to Michigan and started working. I'd like to get on a payment plan and start paying an amount I can afford. So, Mr. Varchetti, how about if I put you and Miss Blanco in a breakout room and see if you can reach an agreement on payment, and then we'll come back and do further record on this. Is that agreeable?
That sounds good, Your Honor. Thank you.
All right. Miss Blanco, I'm going to open what's called a breakout room. Your screen should show something that says join, and then you can talk privately with Mr. Varchetti. Do you see that?
Yeah, I see it now, right now.
All right, click on that button and I'll be back with you in a minute.
Okay, thanks.
All right, this is a very blended record. I'm gonna blend back to a criminal matter. Let me see if I can find it, if it's in my queue. Neither this one or the next one are in my queue. Give me a minute, Mr. Cade. I gotta go on a scavenger hunt for your file.
Okay, thank you.
Darn it. Let me also explain, this matter is before Judge Pattison. Judge Pattison isn't here this morning, so I'm helping to cover a number of things. This is an emergency thing. This is file number 24866SM, People versus Bradley J. Cade. Mr. Cade was charged on or about March 9th of 2024 with domestic violence second offense upon his spouse, Teresa Cade. That's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. Defendant pled guilty to domestic violence first offense, and the matter was set for sentencing out at 10 days out from that. Sentencing is set for Thursday, August 22nd. Not sure what happened.
My attorney couldn't make it.
All right. I don't know if I have a new sentencing date.
October 15th.
All right. It hasn't made it to the file yet. Anyway, it's a condition of your bond that you not have any contact with Teresa Cade. And you got arrested apparently over the weekend.
Yes, Friday.
Violated conditions 2, 5, 8, 9, and 11, specifically number 5. Bradley Kane was found at 205 Jean Street, despite having bond conditions stating he can't be at the residence. Now, I don't know what all these other things, 2, 5, 8, 9, and 11. No alcohol, apparently alcohol was involved, no contact, no weapons, and contact pretrial supervision. So I don't know exactly everything that's going on. So the victim advocate from the prosecutor is here. Do you have any input on this one?
I came to watch, so I can let her know what's going on.
All right, well, 9. Your attorney is Rhonda Ives. She's not here. And Jeanette Jackson from the Public Defender's Office is here helping us. You have pled guilty, so you're no longer presumed to be innocent. Apparently there was alcohol involved, there was a weapon involved, but there was contact. There's a lot going on here that I can't really tell. I'm going to show plead not guilty. I'm sorry.
I'm sorry, there's no weapon involved. Yes, there was alcohol I drank, and
well, don't say any more about it. Set a bond violation hearing or sentence. Or accelerated sentence. Before Judge Pattison. With Attorney Ives.
I had paperwork for the sentencing date, October 15th. I just didn't reach in the cell, but it was 6 weeks.
Well, it could be moved up because your bond is canceled.
Okay.
Hopefully, Judge Pattison will be back tomorrow. They'll get a hold of Rhonda Ives, the prosecutor's advocate. They always do a good job. She'll let Teresa Cade know what's going on. I don't know where this case was headed, but alcohol, no contact, the other issues, I'm going to leave the bond as denied because you've been convicted and you violated Judge Pattison's order. I suspect what they'll do, Mr. Cade, is they're not going to let you sit there until October 15th. They'll try to coordinate a date with Ms. Ives and accelerate the sentence, is my guess. In the meantime, your bond's canceled. We'll let your attorney know that you're in custody and it needs a hearing. So you're good to go. All right. I got another one, Marissa, Larry Barnes and Larry D. Barnes, another no contact violation. That'll be about 5 minutes.
Okay, let me go grab my paperwork on that.
All right, let's switch back to our civil docket. Attorney Paul Marchetti and Katrina Blanco. It says Karina, and somehow somebody put a T in there. Is your name Karina or Katrina?
It's Karina.
All right, I would assume you know how to spell your name correctly. What's on the pleadings is K-I-R-I-N-A. What's on the court docket is K-A-T-R-I-N-A. So your correct name is Karina. As I indicated, this is not a huge amount. It's large if you don't have much money. $1,294.91. Defendant essentially acknowledged the debt. The matter was set for a summary disposition hearing, which maybe I need to explain, but maybe not. We'll see. Mr. Varchetti, were you able to reach an agreement with the defendant?
Yes, I have, Your Honor. And if you'd like me to put it on the record, I'd be more than happy to.
Yes, thank you.
Judge, we've agreed to enter into a consent judgment. The damages are totaling $1,294.91. There's costs consisting of a $55 filing fee, a motion fee of $20, a service fee of $44 for $119 in total cost. There is a statutory attorney fee on this case of only $20 because we filed the motion for summary disposition, which brings the total judgment to $1,433.91. In speaking with the defendant, she is willing to make payments commencing October 15th of this year and on the 15th of each month thereafter until it's paid in full of $100 per month. I've also explained to her that she can give me permission to sign her name with consent to the judgment so that I can get it filed immediately. And she did give me that permission, but I also wanted to put it on the record and get you to have her put it on the record also.
Yes, that's the way to do it. All right, it looks like you had a good discussion. You're going to acknowledge that you owe the debt, $1,433.91. Once we add in all the filing fee, service fee, attorney fee, $150 a month, which would take approximately 10 months to pay this off.
Your Honor, Your Honor, I'm sorry, it was $100 per month.
Oh, yeah, $100 per month. That would take 14 months. Yes, I wrote 100. I'm not sure why I said 150, because I'm losing it maybe from the 15th of the month. Anyway, that'd take about 15 months to pay this off. So you acknowledge on the record that you agree to those terms and conditions?
Yes.
And he can sign your name to the agreement for that amount and that payment schedule, 15th of each month. He will then send me a consent judgment and you can start making your payments. Now, if you can pay more, go ahead and do it. The sooner you get it paid off, the one less thing you have to deal with. But as long as you pay $100 per month, they won't pursue any other collections.
Okay.
All right, do you have any questions?
No.
All right, so this won't be a summary disposition judgment, it will be a consent judgment. Mr. Varchetti, let me give you our email address. Maybe in your library. 3bcivil@stjosephcounty.mi. All right, very good. You do a lot of business with us. All right, yes, thank you for your help and thank you for your indulgence while I was switching back and forth from criminal to civil, but sometimes we have to be adaptable. All right, this is a very fat file for what it was, but the matter has been resolved. Good luck to you, Ms. Blanco, and Mr. Varchetti, I'll see you next time.
Well, actually, Your Honor, I have a 10 o'clock, so I'll
all right, you're on our next one, which is Greg Reed. All right, well, stick around. You can watch our criminal stuff or just put you in the background. I got one more criminal case to do. Ms. Blanco, I'll remove you. She's gone. All right, so let's see who we got. Harry D. Barnes. Good morning, Mr. Barnes.
Good morning.
Let's see who this is. Miss Blanco, you're good to go. I removed you so you could get on with your business.
Okay, thank you. Have a nice one.
All right, thank you. We're working on it. Miss Jackson is having a nice one too. All right, Mr. Barnes, let me pull this up. It wasn't in my queue a minute ago. All right, Mr. Barnes, let me find this file. I wish these would go in my queue. It'd save me a lot of time.
I just didn't know what was I just was in court that Thursday.
Yeah, you were just here on traffic matters on the 5th.
Right, and then I'm walking.
Just a minute. Let me get up to speed. Story of my life. The world's going 65 and I'm going about 50. Maybe less. All right, this is file number 241399SM, Larry Donnell Barnes. Mr. Barnes is charged with domestic violence second offense for alleged assault from July 27th on Shamika Sanders. They got her name spelled wrong in here, but it's Sanders. You posted a bond, and you have bond conditions that you're not to use any alcohol, you're not to have any contact with Miss Sanders or her son, Mr. Sergey, no weapons, no assaultive behavior, and you're supposed to be on pretrial supervision. You pled guilty. Judge Patterson's notes are sometimes hard for me to determine. You pled guilty to MDOP. Sentence is set for October 15th, just like the last guy. The bond conditions, they allege that you were at South Main Shell at about 1:45 on Saturday night. Mr. Barnes was intoxicated. He admitted he'd been drinking. The officer was Matt Britton. You wanted to impress on him that you wanted to beat his ass, and you were taken into custody for violation of bond conditions for being drunk and disorderly while you're on bond pending sentence. Your attorney is Luke Knopfinger. He's not available on this short of notice. Jeanette Jackson is here from the Public Defender Office. Are you still living on 8th Street?
Yes, sir.
All right. I cut you off a couple of times. What did you want to say?
One thing is, it seemed like since he took me to jail for this domestic trial, it seemed like they just harassing me now. I wasn't drunk at all. I just was going to the store to get something to drink, but I wasn't drunk.
So you told him you wanted to beat his ass, but you weren't even drunk?
Because they steady harassing me, man. They steady harassing me. It seemed like after this few times that they grabbed me, you made me pay $100 the first time they grabbed me. I'm like, okay. Then after this, every time we getting in, and that's like going back and forth with each other. And I'm like, what y'all keep harassing me for? Why y'all keep running up on me? You know?
Well, Mr. Barnes, let me just say, I don't believe you. He admitted to drinking. He had a strong odor of intoxicants, and he was extremely intoxicated. And you're saying you weren't drinking. You were going there to get something to drink. You have a bond condition that says you're not supposed to drink.
I'm not.
I don't know anything beyond that. I'm gonna set a bond violation hearing. Or accelerated sentence. The domestic violence charge against Miss Sanders apparently got dismissed. You pled to a malicious destruction of property charge. With Rhonda Ives, your attorney. With Luke Nossinger.
And all I'm trying to
Both
do
of these cases were set for October 15th, but both of these are probably going to get moved ahead. What else did you want to say?
I was just trying to get my affairs together for when I do have to come do whatever I need to do for these cases, man. I want to try
Well, I don't disagree with that. Anyway, your bond's canceled. What they will do when Judge Pattison gets back, hopefully tomorrow, they'll meet with Luke Nossinger, see if they can get a hearing this week. This isn't good. Threatening to beat the officer up, being drunk at 2 o'clock in the morning when you're on a bond pending sentence. So we'll just either move the sentence up or have a PV hearing and then do the sentence. But we'll let your attorney know that you're in custody and we'll set this hearing as soon as we can. All right. You're good to go. Thank you, Ms. Jackson. So both of them were set for October 15th. I'm not sure what I would do is move them up, but it depends on the availability of the attorneys and what else.
I've not heard anything from the victims on that one, so.
All right.
Thank you.
Thank you. Thank you, Ms. Jackson.
Okay, well, we got through it.
Yes.
Well, in one piece.
I still got a bunch more to do, but thank you for your help.
Well, you'll do fine. That's it.
Thank you for your vote of confidence.
Yeah. All right. See you later.
All right. I think that's all the bench warrant stuff I've got. We do have another criminal case with civil case with Mr. Marchetti. And then I have the rest of my own docket.
Is
she leaving? We got another one?
Yeah. This guy?
Just a minute. This phone is funky.
The ticket says 130.
Hi. Would you hold on to Jeanette? I need her for a second. All right, thanks. Bye. Good morning, gentlemen.
Good morning, sir.
All right, thanks. I needed some more stuff to do.
I don't know why the tickets are saying 130, but Lupita received a phone call about somebody having a time at 1:30 as well.
That was me. I called and I just showed up because I just didn't want any.
Well, good. Well, I'm glad you're here. Your ticket did say 1:30. If you showed up at 1:30, we would have taken you. But the trooper who wrote the ticket made a mistake. But anyway, you're here and we'll be with you in just a moment.
Thank you, sir.
Oh yeah, she gave it back to me. Did you not make her way out?
We're still looking.
All right, maybe she used the restroom. Hopefully we can catch up with her. Let me see what the deal was on this one. Should be pretty straightforward. All right, the record's still on. It's going to be a very blended, half criminal, half civil record. Beautiful day out there today. It's kind of windy over the weekend, but it seemed quite nice. Stuck my head out there for 2 seconds. All right, Mr. Varchetti, when we get back to this one, it doesn't appear this defendant's going to be here.
No, we didn't receive a response either, so it's unopposed.
All right. Close my on base by accident. This is file 24531GC, LVNV Funding versus Greg Reed. It is a claim for $1,192.02. plus cost, interest, and attorney fees. Now there's Bradley Cade. Attorney Paul Varchetti is here on behalf of LVNV Funding. The defendant did file a letter, and I'll take it as an answer, dated March 30th. I'll read it as it's written. I have reached a deal with them to pay $25 in June, pay $100 after that for 9 months. I will do that to pay it off. That's not even the right case. That's Midland Credit Management, so that isn't even this case.
Nor has he made any payments, Your Honor.
All right. Well, let me see. He had the file number 24531. That's this file number. So it's got the file number correct. All right. So let me make sure he's not here. Would you check to see if we have a Greg Reed out lurking in the hallway? You probably have been here. Have you been to Centerville?
I have not been to Centerville, only via Zoom. All
right, well, you're missing out, but it's hard to get here from there. It really isn't on the way to anywhere else, but maybe someday you'll get to come here. Defendant's letter has correct file number. All right, but wrong plaintiff. Per Attorney Varchetti, no response. No payments have been made. Certainly, you're entitled to summary disposition. Would you rather have a summary disposition judgment or just a default judgment?
I prefer the summary disposition, Your Honor.
All right, I'll grant summary disposition. The rules are different if they move to set it aside. Let's nail down the numbers here.
Yes, Your Honor. Damages are in the amount of $1,192.02. Costs consist of a $55 filing fee, $20 motion fee, $45 service fee for total cost of $120. $20 statutory attorney fee brings the total judgment to $1,232.02.
I don't believe I have an order in here. I looked, the file's quite fat. So I'll grant the motion for summary disposition in the amounts that you've indicated and ask you to email me an order and I will sign it.
We'll get that with the other order from the 9:30, Your Honor.
All right, very good. You got to experience a little bit of criminal bench warrant arraignment too, so that enriched your morning. All right, I'll see you next time. Thank you.
Thank you, Judge. Have a great day.
All right, we're working on it. Ms. Jackson, thank you for coming back in. We had an arraignment come in, and I appreciate his being here. Mr. Kinsey, would you come up to the podium? This is file 241547ST. It's entitled People of the State of Michigan versus Harley Davidson Kinsey. Mr. Kinsey was charged with driving with a suspended driver's license on August 16th. In defense of Mr. Kinsey, the trooper gave him a ticket that gave him an appearance time of 1:30, which is not correct, but if he would have shown up at 1:30, we would have taken care of it then. How did you know to be here now? Did somebody call you from the live feed or something?
I was looking at the ticket. I went over to Branch County and took care of the initial fine that got my license suspended. And then I had some time and I figured, well, I wonder if I can come over here and just pay the fine. I wasn't aware that I had an arraignment. I thought it was just a ticket.
All right, well, you're here, so let's deal with it. Driving suspended is a misdemeanor, as I said. It's punishable by up to 93 days in jail and a fine of up to $500. Wrong time on ticket. More importantly, it requires that your driver's license be suspended, and it carries 2 points. Attorney Andrew Rognus, who's working with the prosecuting attorney's office, has reviewed this and indicated if you paid off those tickets, he would reduce this to a charge called allowing another to violate the motor vehicle code. That carries no points, it doesn't go on your driver's license, it won't further restrict your license, it can allow you to get your license straightened out.
Yes,
however, it is a misdemeanor, it's punishable by up to 90 days in jail and a fine of up to $100. Plus costs. Do you understand the charge?
Yes, sir.
It's a good offer because it won't undo your efforts to get your license back. And I do appreciate Mr. Rognus giving me these offers in writing since he wasn't able to be here. Are you willing to plead to that lesser charge?
Yes, sir.
Anybody threaten you to get you to plead to this?
No, sir.
Well, I'm glad you're here. We're able to take care of it on the morning it was scheduled for.
Yes, sir.
And we're going to have to work with the state police on getting these times straightened out. But 1:30 in the afternoon would be right in the middle of Judge Patterson's domestic relations docket or my landlord tenant docket. But we always take people if they come in, no matter what time it is. All right, where were you going?
I was headed home from Borough. We live in Bronson area. I was headed home and we got pulled over. And that's when he informed me that my license was suspended. I had gotten a new truck, got pulled over with a proof of no insurance. I went into the courthouse that immediate next day, showed him my proof, and I failed to come in and pay the ticket. Just my own stupidity. It completely slipped my mind.
Well, it sounds like you're going to be cleared now. Take a look here. I'm surprised I didn't think they were suspending people for that anymore. You got almost pristine driving record.
Yes, sir.
Except for that.
Yes, sir.
Well, the good news is this isn't going to hit as a DWLS.
Thank you.
The only thing you ever had on here is that. I don't know what they do in Coldwater, but I didn't think we were allowed to suspend people for failing to pay a ticket. But they did. Your license expires in September.
Yeah, just yesterday was my birthday, sir. I'm waiting to get this squared away before I go in, and I'm sure there's a reinstatement fee or something.
All right, well, the good news is this won't show. Hopefully, if we do it today, it'll disappear. All right, I'm going to reduce the fine from 100 to 75.
Thank you,
$75 crime victims' rights fee and a $50 state minimum fee. $200. Can you pay that today, or do you need time to pay it?
I can pay it today, sir.
All right. All right, let me just, this is a misdemeanor. We might as well do it right. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you have the right to have an attorney to represent you. If you wanted us to appoint one, we could. You could also hire one of your own choosing. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, judge or jury could not hold your silence against you. And you have the right to be presumed innocent. Now, it's a pain in the neck to just do a walk-in at the Secretary of State.
Yes, sir.
So you can try that, or make an appointment maybe for tomorrow and go in and get your license renewed. You got a driver with you today. All right, you owe $200. You can go out to the counter and pay it. I'll give you your ticket back. I'm glad you're here. This will not suspend your driving record. And we got to get it entered so it clears that DWLS ticket off of there. So I'm going to have the bailiff take you out. You can pay the fine. And then I recommend that you go to SOS and get your license renewed.
Yes, sir.
Your license is almost as clean as anybody's I've seen in a while. Literally, the only thing on, you had a ticket back in 2016.
Yes, sir.
But that wasn't even a driving thing. All right, go pay that, get your license, and you're good to go.
Thank you, sir.
All right, his parents had a Norton 750, so they called him Harley Davidson. All right, thank you for your help. I think I'm actually caught up. I'm back to my own docket, which my next thing is.
Shall I walk slowly this time?
Well, go to your house and drag you back. I have a couple of sentences with the assistance of a translator, which are always difficult. I think they're 2 J Felt cases. All right, see you soon. Thank you. All right, I do have to make a final record on John Allen Kettlehut, file 2301FY. Mr. Kettlehut was set for a probation violation, failed to appear. I'm going to do a bench warrant with no 48-hour hold and no bond. See Judge. This is Judge Patterson's. Casey Strong is his lawyer. I do have a phone number. Let's see what the deal is. Good morning. This is Judge Middleton calling for John Allen Kettlehut.
No, he's not here. He's not with me.
Well, I've just issued a bench warrant for his arrest for failing to appear for a court appearance this morning.
Yeah.
So if you see him, you let him know there's a warrant for his arrest. He needs to turn himself in.
I'll be honest with you. I don't think he's going to be around long. He's mentally gone. I mean, he plans on killing himself, what he says.
Well, that's not helpful. He needs to get here and we can help address it. All right.
Yeah, I know he needs help.
Now, who am I
trying to get his, this is his father.
All right.
We've been trying to get him help, but in this state, there ain't no help for him. I mean, Pivotal, which took over for the healthcare system here, a few months ago, sent him a letter discharging him because he wanted to see a therapist, not a psychiatrist.
All right. Well, if you do have contact with him, tell him he needs to come in.
Let him know.
All right. Thank you.
We've been trying to talk to him, trying to get him to get some help.
All right. I'm all in favor of that. All right. Thank you, sir.
Okay. Thank you.
Bye.
God bless you. Now.
Right, thank you.
Bye-bye.
Well, that's not very good. He is correct. There's not enough adequate mental health service here or anywhere, as far as I can tell. I'm familiar with Mr. Kettlehut. I've dealt with him in the past and his dad. That was actually set before me, not Judge Pattison. No, that was Judge Pattison. All right, I'm going to stop this record in about 12 minutes. I need to come back for some misdemeanor sentences. All right, we're back. Ready to start our landlord tenant docket. Already got people in the waiting room. Took a walk at lunch. Quite warm. First two cases were settled, are 115 and 120, so let's go ahead and get started. Excuse me. Good afternoon.
Good afternoon.
I have somebody in the waiting room. Let's see who it is. Just before I came in, I got an answer from the defendants. Did you get a copy of that?
No, I did not.
All right, we'll email it to you if she put it in my queue. That's Miss Wayne. Hello. Let me see if it's in the... No, that's tomorrow.
And did you get an answer? Is it on the mobile home park or the elm tree?
Mobile home park.
Okay, I thought so.
And you don't have it?
No, I don't. No.
All right. I don't know if I've got your new email in here. Let me check. Well, I've got Cooley EDU and
Elaine is wonderful. She just emailed it to me as we were talking.
all right, she's very smart. Okay, thanks. Here's Zoom user. You've done a wonderful job decorating your new office.
Thank you very much.
Very minimalist.
All of my diplomas are sitting on the floor in the corner, so I have to work on that. And Melissa, I just sent you copies of those answers, so we can talk about them later, but I want you to have copies.
All right, I'm sending you something now.
Thank you.
Here's a phone number. All right, we are on the record. We're about to start our docket. Got someone who logged in as Zoom user and they just disappeared. I've got someone with a phone number ending in 9543. Who am I speaking with?
Speaking with William.
With who?
William Wadsworth.
William Wadsworth?
Yep.
Is Miss Jackson with you also?
Yep, I'm right here. Kinda.
Can't see you, but I can hear you.
Sorry. Hi.
Oh, there you are. Very good. All right. So you're here as Zoom user and the phone also?
I don't know.
Well, let's give you a name. Mr. Wadsworth, could you remove your hat?
Oh, yes, sir. Sorry about that.
Well, it's very informal. We are in a court proceeding. All right, so we've got Mr. Wadsworth and Ms. Jackson. We've got Ms. Wing from Sturgis Mobile Home Park. We've got Casey Strong, Esquire. And we've got a phone number that I'm not sure who it is. Mr. Kanan will be with you in a minute. I think we're set for 1:45 on yours. That's what I've got.
Yes, Your Honor. Thank you.
Okay. In the meantime, let's address this. This is a landlord-tenant matter where the plaintiff wishes to terminate the tenancy of the client. Ms. Wadsworth and Ms. Jackson, we'll do that one first. The file number is 241243LT. As tenant in a landlord-tenant proceeding, you have the following rights. You have the right to have an attorney. If you can afford one, you can hire one of your own choosing. If you can't, you can see if legal aid will assist you or get other legal assistance. There is no court-appointed counsel for civil matters. I do see that you have been in contact with the with legal aid and with Housing Resource Center, Fair Housing Center. You have a right to have the matter heard here in St. Joseph County where the property is. You have a right to demand a jury trial. If you do that, you have to do that at this initial hearing or file the demand within 5 days and pay the $50 jury demand fee unless you receive a waiver of that fee. You do not, well, that's, if you do reach an agreement with the plaintiff outside of court, we could file something called a conditional order of dismissal. You may be able to reach an agreement with your landlord by going through mediation. If both parties are interested in that, the court can help set that up. This is filed as a just cause termination, listing health and safety and quiet enjoyment issues filed by the plaintiff. One thing I was unclear on, Ms. Strong, is this lot and trailer or just lot?
It is lot and trailer. Oops, excuse me, it is just lot. And it has been filed as both under 600.57752 and 600.5575F.
Lot only. These are problematic. They wish you to remove your trailer from this lot. You filed an answer generally denying all the allegations and listing a number of defenses. They're not asking you to pay the rent at this point. They're asking you to remove the trailer. The law requires that I schedule this matter for a second hearing. My staff forwarded a copy of that answer to the plaintiff.
Thank you.
Thank you, sir.
There was an email from Mr. Kupferschmidt. They closed this out at legal aid. I'm not sure what the status of that is, but what's your position? They want you to move out and move your mobile home.
I don't know, I guess you're a little lost because this, all of those violations came in on like 1 to 2 days. Like, we haven't heard or really seen from her before that or now after that. We got that lawyer back on May 13th when we got the 8 violations or whatever, and it was July 25th that he closed it out because we had not heard from her. So we just recently finally got back in contact with him to have him reopen the case, but he couldn't make it here on short notice, so today anyway, so he filled me in.
The law requires that I heard this in at least 7 days.
Okay.
And Your Honor, if I could request from the defendants that once they get in contact with that attorney, to have him reach out to me so that we can start discussing this matter and talk about some kind of resolution.
The way this works, if they get what they ask for, you would have 10 days to move out and 90 days to move or sell the mobile home. Termination of tenancy in a mobile home case is under a different set of rules. But nothing is going to happen until we have at least one more hearing, and that will be next Monday, the 16th. At 2 o'clock. Does that work for you?
I will make it work, and then to the defendants, since we are on such a short time frame, have that attorney reach out to me as soon as possible so we can start talking about this.
Okay, yeah, absolutely. We'll get a hold of my manager.
Apparently this has been in the works for months. You got some sort of notices in May. They, being legal aid, was in the wings waiting for something to happen. Nothing happened. They closed the case, then something happened. So we will address this further next Monday at 2 o'clock by Zoom like this once again. You're always welcome to come in, but if it's more convenient, you can do it by Zoom. So I will see you at that time. Do you have any questions?
Nope, not right now. Thank you.
All right, thank you. I'm not sure why Miss Bauer isn't here from legal aid today. She must have a conflict, but she may have been able to shed some light on this, but you're on their radar, so I would contact them immediately.
Okay.
Thank you.
All right, see you next week. Now the other case, we jumped over it. It was set for 1:35, or maybe we didn't. Butch Baker versus Cox, and I have received a conditional order for dismissal. And here's Mr. Weiss now. Good afternoon, Mr. Weiss.
Good afternoon, Your Honor.
Miss Strong hung around just so she could say hello to you, so got that going for us.
I appreciate that.
And for my 115, Judge.
Oh, I skipped your 115, but the one I don't have the 115. What is it?
Versus Cinquez Furlough.
I saw you put Elm Tree. Let me look. It's not in my queue, and Elaine told me the one.
I have nowhere to be as well.
All right. I have nowhere to be either, except here. So, Mr. Weiss, let's talk about your case, which is Butch Baker versus Cox. Now, someone's logged in as Samsung. Who am I speaking with?
This is Jonna Cox.
All right. And Jonna Cox, I've received a consent order for conditional dismissal signed by both parties. Rent is $1,940.65. Court costs are $231.30 for a total of $2,171.95. And the defendant has agreed to that conditional order. Is there anything else, Mr. Weiss, I need to know?
No, Your Honor. I believe that's it. She's indicated she's going to try and have that paid by September 30th, and if she does, then we won't enter judgment.
And that's a benefit. Right now, if it entered today, the date would be September 19th. And even next week, it would be the 26th. So they're giving you till the end of the month. So that's the benefit. All right, Ms. Cox, I'll give you the same advice I give everyone else. Stay in contact with your manager and let him know what your intentions are. I've signed that order. You've got till the end of the month to get caught up on that, and hopefully you can.
Thank you, Your Honor. I appreciate it.
Thank
All
you.
right, good to go. All right. Let me see, Ms. Strong, if I could find that case. Elaine, if you can help me. I don't have a single furlough landlord-tenant case set. I spell her name wrong. S-Y-Q-U-C. (241365) or 241173?
241173, Your Honor. It's a non-payment of rent.
Oh, somebody else was in it. Probably Elaine. Defendant called to say she could not attend the hearing on 9/9 because she was having surgery. I rescheduled the first hearing on 10/11, along with the other case, 241365. That was on August 28th.
We never got a renotice of hearing on that. Sorry about that.
Well, I'm sorry. Now, it's even worse. I'm going to California for a funeral of an old friend on that day. So we're gonna have to reschedule it again. I'm not sure. Today is the 9th. That was the 28th. You certainly should have had a notice by now. Maybe they sent it to the old office or something.
And this is one of the, this is the firm's case, so.
Well, she has she had two files, and so it's confusing. And so anyway, I'll find out what's going on. So theoretically, it's set for October 11th, along with a bunch of other messy stuff. But that's the day of the funeral service. And so we'll get back to you with where that is, but it is not on that date. And I apologize that we didn't give you notice. So
not a problem. I was here anyways.
Yes.
We'll
all right,
out.
yeah,
we'll
that worked out. Okay, I will. We'll get up to speed on when and where we're going to do that one.
Okay, thank you.
All right, thank you. All right, so our next matter is Whispering Pines, but that isn't until 2 o'clock. Mr. McNair is here on our general civil cases. Let's talk about those. We have credit acceptance versus Chelsea Beer. Is that the one you're here on?
Yes, it is, Your Honor.
All right, let's see who's here. Besides me. I spent a lot of time in this room by myself. This is Ethan, and this would be Ethan Flanagan on a discovery hearing. Is that you, sir?
Yeah, that's me.
All right, you're a little early, which I appreciate. Counsel isn't here yet. Both of these matters are set for 1:45, and then we have another 2 o'clock landlord-tenant case. we have a short break, and then we have some landlord or some small claims cases. This is the part where we just sit and let the clock tick. Do a lot of that. It's called dead air. I'll give Mr. Flanagan a name. Here's iPhone. That may be Miss Beer. Mr. Flanagan, are you at work?
Oh, no, I'm home.
Okay. Good afternoon. Are you Chelsea Beer?
Yes.
All right, let me give you a name here rather than iPhone. E-E-I-E-R. Doesn't look right. All right, it's 1:43, close enough. We're going to call the matter of Credit Acceptance Corporation versus Chelsea Beer. Mr. David Canine is here for credit acceptance. The defendant is here in pro per. In 2022, the defendant entered into a consent judgment in a substantial debt, $16,510 plus costs made it $16,818.23, I believe it was. She was going to pay $50 every other week beginning October of 2022. That's pretty generous on a $16,000 debt. It's about $100 a month, which would be $1,200 a year, which would take about 14 years or more to pay a debt of this size off. In July, the plaintiff filed a motion to set aside installment payments, saying she hasn't been making any of the payments, and she has not complied since August of 2023. The defendant responded with a letter to the date stamped August 5th, saying, I haven't made the payments, but I haven't been able to make the payments. So I could have simply granted the motion to set aside the installment payments, and then the defendant would have petitioned for installment payments, and then we'd chase ourselves around. In the Zoom era, I've been setting these for a hearing, not having to drag plaintiff's counsel all the way out here to Centerville or hire some local counsel. But Ms. Beer, you have a judgment against you and a substantial amount of money. You haven't been paying on the debt, They had a very generous repayment agreement. I think under the theory that collecting some was better than none, but now they're back to none. Your position is you barely have enough money for food and electric bills, let alone this old debt. But they're not going to go away and play dead. They want to collect on this debt. One of the manners they could do that would be to garnish your wages, which you would not like. It would be substantially more than $50 every other week. What's your position?
Well, Your Honor, we actually had a court date last year because they put another one of these out for me, and I was making the payments up until they took my taxes, because one of the agreements last time was when I got my taxes, they might be able to make a deal with me that I could pay them $3,000 and this debt be wiped away. Well, I could no longer do that because even though I was making payments to them, they also took my taxes. And then therefore after that, yeah, I did stop making payments because I felt that if I'm making payments to you, you should not try to take my taxes also. That was my only way out of this, was to try to pay it off that way.
Well, I don't know if there was ever an agreement to pay off a $16,000 debt for $3,000, but nonetheless, they're in the business of attempting to collect on this.
I think we went into a separate room with whoever was.
Yes, I'm about to do that again. Okay. Mr. Canine, what's your position?
Excuse me, Your Honor. I'm here for another law firm, Rooson's office.
Yes.
I don't have any authority. If you'd like me to talk to her, I'd be happy to. She hasn't made a payment in over a year. And the interception of her state income tax refund, as the court knows, wouldn't have any bearing on her monthly payment arrangement and obligation. So,
Your Honor, that in over a year is incorrect. I should get on my online payment thing and see my history. Should have done that before I got on here, but I had to leave work quickly. I did make payments because we were just in court last year over this.
It's already September.
Yeah, I think your last payment was August of 23, which is now it's September. Are you still working?
I am.
Where is that?
I work at Warehouse Designs in LaGrange, Indiana. And I've been there since July 10th of 2023, and our last court date, I was actually doing a Zoom meeting there at my job, so therefore I know I was making payments past that time.
Yeah, your last payment was August of 2023. Now, unless you had some weird circumstances with your taxes, your state income tax refund is usually much smaller than your federal tax refund.
It was over $3,000, and they took all of it.
Which is their right under the collection law. They can't garnish your wages. They can make non-periodic garnishments, such as an income tax refund. So what they want me to do is reinstitute a garnishment, which you will not like. So you got mad and stopped making payments. I'm sorry, say that again?
It's slow with the interruptions. I'm not trying to interrupt you. I said at that point, I might as well not work.
Yes, and their position is we're not getting anything now. So what's the difference? Anyway, you're stuck with this great big judgment. Is it accruing interest, Mr. Canine, or did they forego interest?
No, it is accruing interest, Your Honor. At the lower money judgment rate, though.
What is the current arrearage?
The amount due and owing, Your Honor, is it's like $12,123.
Which is so insane to me because they got over 11 grand for this truck at auction. Plus they took over 3 grand of my taxes. Like, how much is this truck worth?
Well, that ship sailed a long time ago. I see lots of terrible cases where somebody buys a used vehicle at very high interest rates. They get behind on their payment, the vehicle gets repossessed, it's sold at a relatively low price at auction, and you're due for the balance. I see it all the time. These are among my least favorite kinds of cases. But they didn't do anything illegal, and nobody made you sign that contract, and nobody made you sign this consent judgment. So they have a judgment, which is an order that says they can collect money. And plus there's interest. So $50 every other week probably barely covers the interest on this debt. So
I know, and I made that arrangement because I was probably going to end up filing bankruptcy, but I'm not able to because of money also.
Do you have other debts?
I do. What I make just covers gas and food because I don't get any kind of state help. And then my daughter gets a supplemental Social Security check for having seizures, and that covers rent and electric. That doesn't even cover the propane I have to put in my tank outside for the winter. So just kind of everything just has a place, and just trying to make it work.
I'm certainly aware of that, which is why I set this for a hearing. This involves real people, real life. They can't garnish your Social Security, your daughter's, but your wages are fair game. And you made some bad choices regarding the purchase of this vehicle and its repossession, and you're stuck with it, and so am I, and they're not going to go away. And so maybe they could have worked out some lump sum agreement. I don't know. Apparently it never happened. You got mad and stopped paying. I could have simply signed the order and they would have started garnishing your wages, which would have resulted you in either quitting your job or filing bankruptcy, in which case they wouldn't get any money. So it is a difficult problem without an apparent solution. So I'm going to put you and Mr. Canine in a break. Problem is I'm going to need the breakout room in a minute when Ms. Salisbury joins us. But we'll see what we can do. So I've only got one room open. All right, both click join, and you can talk to each other. All right, let's set this aside for a moment. We had a couple of discovery hearings. Omni Credit Union file 24121GC. Apparently we don't have service on that one. However, we do have Omni Credit Union versus Ethan Flanagan of the clan Flanagan here on his own behalf, and Stacy Salisbury is here on behalf of Omni Credit Union. This is a discovery hearing, an attempt to discover the ability to collect on this judgment. Again, it's substantial. It's north of $16,000. And it also had to do with the purchase of a vehicle, which I just expressed are among my least favorite kinds of cases. Good afternoon, Ms. Salisbury.
Good afternoon, Your Honor.
Mr. Flanagan, the first thing I'm going to do is I'm going to ask you to raise your right hand. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You can put your hand down, thanks. All right, now I'm going to put you in a private space with Ms. Salisbury, and she's going to ask you some questions about her ability to collect on this debt on behalf of her client. You have to disclose things that she requests, like bank account numbers, social security numbers, that sort of thing. And I just opened the breakout room for the last disgruntled client, so I have to wait a minute. Are you still at Lincoln Street in Sturgis?
Correct.
Are you employed?
Yeah.
Where's that?
Wedgwood Brewing in Middlebury.
Wood Brewing?
Wedgwood Brewing in Middlebury, Indiana.
It's a brewery?
Yes.
What do you do there?
Cook and clean in the back of the restaurant.
All right, Mr. Canine is back. Let me bring him in. Is she still in the breakout room? Take me 60.
Sorry.
I'll bring her back. It takes me 60 seconds of my life to do this. If I total this all up, it's about a year and a half that I've aged waiting to close breakout rooms. I was much younger when I started here in 1980. I didn't have any gray hair. All right, Miss Beer is back. All right, Miss Beer, bear with me here. Let me reconfigure my breakout room.
Okay.
All right, now, Mr. Flanagan, I say this often, if you don't have any money, you don't have any money. They can't execute on you if you don't have any money. You do have a job, and she's got to inquire about other assets and ability to collect on this. So you're under oath. I'm going to put you both in a breakout room. Ms. Salisbury can unmute, and she'll have a chance to ask you these questions. I will be here when you're done. When you come back, we'll see what you've accomplished. So click the button that says join, and I will see you in a few minutes. All right, let's go back then to credit acceptance versus beer. Parties were put in a breakout room and didn't take very long. Mr. Canine, what's the status?
Your Honor, we had an opportunity to speak. Ms. Beer is under the impression that there might be a lump sum arrangement at some point. She has made some payments. She really doesn't have any more disposable income to offer. I don't have authority to withdraw the motion to set aside the installment payment order, but I guess I would just leave the decision within the sound discretion of the court.
Well, I think what I'll do is I will continue the matter, directing that someone from Rusin and Varchetti appear with settlement authority, and we will discuss it further.
I would actually like that, because I actually just went in my email receipt, and because I was saving them, and my last payment to them was January 8th, 2024, yeah.
All right,
I
well,
kept
that's
some of those receipts.
okay, good. Well, so that only means you haven't paid in 9 months rather than 12.
Hey, Paige, the indignation here is a little inappropriate given that it's been 8 months since she's made a payment. And I don't even know if that's true or not. But that having been said, if the court wants to continue her on the installment payment arrangement, I don't have any objection to that.
All right, well, I'll do that. Would you be willing to continue at $50 every 2 weeks?
Yes, I'll do that.
All right. Thank you, Mr. Canine.
Yeah, I should have been more clear about that, Your Honor. I apologize. So,
the indignation rubs me the wrong way too, but I'm trying to keep my objectivity. Continue the inconsistent payments, rather, the installment payment, not inconsistent, although they are consistent. And continue the installment payment orders of $50 every 2 weeks. See what kind of order I have here.
When would that begin, Your Honor?
Well, we're going to talk about that.
Okay.
The motion. I don't have an order. When would you like it to begin?
Let's say September 28th.
All right, that's fine.
Does that work, Ms. Byer?
Yes.
Okay. Thank you, Your Honor.
I will ask my staff to draft the order. She did the motion. Or you did. Let me see if I have an order in here somewhere. I do. All right, the motion is denied. Defendant will continue. $50 payment every 2 weeks. Starting September 28th. All right. And Ms. Bayer, you certainly shall be credited for every payment that you've made. If you did make payments in January, they'll certainly keep track of that.
Right, Your Honor.
All right, the motion to set aside the installment payments is denied. We're going to recontinue under the original order. Are you still at Aldrich Lake Road?
Yes.
All right, very good. So they're not going to garnish your wages. I know you're going to struggle even to pay this, but it's certainly much better than 25% of your wages. So, all right, Mr. Canine, thank you for your help.
Very good. Thank you. Thank you, Your Honor.
Thank you.
Oh, I'm sorry. Were we done, Your Honor? I didn't mean to cut you off.
We're all done. We're all done.
Okay, very good. Thank you, everyone. Bye-bye.
All right, so let me remove everyone. All right, Mr. Jarvis, if you had landed in one spot, you're making me dizzy.
My fault, Judge.
All right. Our next matter is Whispering Pines 2 versus Joshua Jarvis. Mr. Timothy Reed is here on behalf of the park. Their manager, Rebecca Lentz, is also here. Let's back up a little bit. This is a demand for non-payment of rent. We were first here on August 9th. We determined that the rent at that time was $5,650. The matter was continued to August 23rd, no payment had been made. Mr. Reed showed up, Meg Bauer was here from Legal Aid, and Rebecca Lentz. Mr. Jarvis was not present, and a default judgment entered on behalf of the landlord in the amount of $5,400 plus $186.75. Mr. Jarvis didn't show up. I'm not sure why he didn't show up, but he filed a motion to set aside the default. In order to set aside the default, Mr. Jarvis, you have to show good cause as to why you didn't appear. You're supposed to file an affidavit of meritorious defense, which I don't think you've done, but you did file the motion and I set it for a hearing. What's your position here?
I had a interview for a job that day, and I just spaced out completely that court. But I have since been to the IRS meeting, and I will be paid anytime. It'll be direct deposited. I've spent 3 days in South Bend this week getting that money, that meeting with the IRS figured out. They'll be paid as soon as humanly possible.
Well, all right, neither of those, that isn't a good reason that you spaced out and forgot to come. And the fact that you got money coming in is not a meritorious defense. However, the plaintiff may relinquish the right to evict if they knew they were going to get a substantial payment. Mr. Reed, what's your position?
Excuse me. Thank you, Your Honor. I believe the court stole my argument that, or the court ruled that a meritorious defense and good cause has not been shown in this matter. And we just ask the court to deny the motion. Obviously, my client has 56 days from the entry of the judgment or from the vacation time whether or not to seek a writ of eviction or not. So I would just ask that the court dismiss Mr. Jarvis's motion and allow this to proceed.
If I pay in the next 56 days, are you going to evict me?
Well, the one thing we need to do is we need to figure out what date. That was August 23rd that you failed to appear, and the date for the writ would have been September 2nd. September 2nd has already passed. And so theoretically, they can evict you today. However, as Mr. Reed says, they have 56 days from today to ask for the writ of eviction. So I'm kind of reluctant to put the September 2nd date on here. Mr. Reed, are you willing to give 10 days from today?
Please. Your Honor, that's fine. The reality with getting Mr. Morris out there in a shorter period of time than that is probably not going to happen anyway, so.
All right. Motion to set aside default denied.
If the money shows up.
Just a minute. Defendant agrees to 10 days from today, or plaintiff agrees. So they've agreed to give you 10 days from today, which will be September 19th, to pay this or be subject to being evicted. Now, they don't even have to evict you then. They have 56 days from September 2nd, I guess, to ask for the writ of eviction. But we're going to use this date. Now, you've been saying since mid-August that the check was in the mail. And
now it actually is.
Say that again?
Now that it actually is, I actually just went to the IRS building, direct deposit
Well, if you get
anytime.
it within the next 10 days, go pay the rent, and you're good until October.
I appreciate it.
Centered. Acceptance of a partial payment won't prevent the writ of eviction. The date we'll use 9/19.
Hey, that's my birthday.
I hope it comes, and I hope you pay it and everything is good.
It's all good, Judge. It's coming. There's no doubt. I spent 6 hours at the IRS building from the time they opened to the time they closed.
All right, stay in contact with Miss Lentz. Motion to set aside default denied. You look like you're in a room with a black light. I'm not sure what, or a haunted house or something, but
haunted park.
All right. Okay, 5,586.75. They've given you by grace an additional 10 days.
I love
if
you
you
for
pay
it.
that. All right, motion to set aside default is denied, and you got 10 days to pay or be subject to being evicted.
Thank you, Judge.
All right, thank you. Thank you, Mr. Reed and Ms. Lentz.
Thank you.
Have a good day.
Yep. Rebecca, I'm going to give you a call on some other ones as well after we hang.
All right. Thank you.
You bet. Have a good day.
All right, thank you.
Well, Judge,
All
thank
right.
you. You're not streaming today?
I am.
Oh.
Yeah, I am. Just for you.
Normally I have
Judge
a light
P-
that blinks in my corner that tells me.
Judge P isn't here, and I don't think he's going to be here tomorrow, so they've kind of doubled up today.
Oh, jeez.
Okay, I will see you next time. Thank you.
Thanks, Judge. Have a good day.
All right, that finishes our landlord-tenant docket and civil docket. Ms. Salisbury and Mr. Flanagan are still in the breakout room. All right, I'm gonna stop the live feed rather than have you all just watch me sit here and wait for them to finish the discovery hearing. We will be back at 3 o'clock with 2 small claims matters. Good afternoon. It's almost time for our small claims docket. I believe I have Matthew Rink and Lexus Gentz having logged in. Would you please unmute your mic and open your video screen? Good afternoon. Are you Lexus Gentz?
Yes.
All right, we'll be with you in just a moment.
Okay.
Mr. Rink, can you hear me? Oh. Good afternoon, sir. All right, we have one plaintiff and one defendant, but they don't match. It's 3 o'clock, and we're here for small claims. Let's see if anybody else comes in. Mr. Rink is a plaintiff in a mini tort or a auto damage accident. Ms. Gentz is a defendant in a landlord-tenant damage hearing. We don't have the defendant in Mr. Rink's case or the plaintiff in Ms. Gentz's case, so well, let the clock tick a little bit. I spent a lot of time doing this, sitting here waiting for something to happen. Let's check with the bailiffs. Hi, do I have any other live customers out there for a small claims court? All right, thank you. Bye. Well, neither of the other parties are here. Ms. Gentz, have you had any further contact with the people at Magic Capital LLC?
No.
Did you get the letter from Ms. Davis setting out what they contended the damages were?
So I vacated the premises on March 10th, and I received a letter from Debbie on April 18th.
All right. Well, let's wait a minute. We're not under oath yet, and nobody else is here. I could understand perhaps why the defendant wouldn't be here, but I would think the plaintiff would be here.
Yeah.
As I stated, I spent a lot of time waiting for people to show up in a timely manner. You guys are both here in a timely manner. I'm going to take up Mr. Rink's case first, see whether anybody shows up.
Okay.
While you're here, I might as well, at the risk of having to do this more than once, you're both here on a small claims matter. Small claims is a separate division of the 3B District Court Civil Division. In small claims court, you can sue for up to $7,000. In general civil court and district court, you can sue for up to $25,000. In small claims court, the rules are different. They're more relaxed. Neither party is allowed to have an attorney. There is no formal record being made of these proceedings, although they are being live streamed. Neither party has a right to appeal. Any decision made at small claims court is final. There is no appeal from small claims court. Either party has the right to remove the matter from small claims to the general division of the court. You have to tell me that before we begin. Once we begin, any decision made here is final. Mr. Rink, you accept that?
Yes, sir. Yes, Your Honor.
All right, well, let's call your case. Matthew Rink versus Kimberly Janeth Ramirez Garcia. Mr. Rink has filed a claim for $7,000 as a result of an automobile accident that occurred in June of this year, I think the 24th, where it appears that Ms. Ramirez Garcia rear-ended his car as it was stopped at a stoplight, causing extensive damage. Ms. Ramirez Garcia did get a ticket for failing to yield and filed 24101356-OI. She admitted to the failed to yield violation and paid the citation here at the courthouse. The trooper issued the ticket to Ms. Garcia for this collision. This is filed under small claims, but the mini tort statute applies. According to the ticket, Mr. Rink, you had Progressive insurance on your car, is that correct?
Yes, Your Honor.
And according to the ticket she got, she had Indiana auto insurance. Do you have anything to prove that she did not have auto insurance at the time?
I did not know that, and then I got the police report, and it says who her insurance company was, and then I called my insurance company, and they verified that it says what she had from the police report. So I called up the insurance company, Indiana Farmers Insurance, and they said that they had no recollection of her having insurance. So I called back my insurance company and told them that, and then they looked in further into it, and they told me that that she did not have no insurance at all.
At the time of the accident?
Yeah, at the time of the accident, yes, sir.
If you had insurance and she had insurance, and there was a collision, under the no-fault statute, the most that she could be responsible for would be $3,000 under the mini tort statute. However, if your vehicle was parked for some other exceptions, or she doesn't have insurance, she's liable for the entire amount. If you don't have insurance and you get in an accident and you get sued, you're not protected by the mini tort statute. You provided information that the repairs to your car were quite expensive. One quote in the $8,000 range and one quote in the $14,000 range. Have you had your vehicle repaired?
No, Your Honor, it was more than, it would cost me a lot of money to have it repaired. Because my insurance company wasn't gonna pay for it, because I had the POPD.
All right. Is it true that, let's take a look at this. One quote was $8,498, and that was from USA Auto Body. Is that correct?
USA Auto Body quoted me $14,000, and then $8,400 and some odd dollars what I paid for the car.
Oh, so that was the total amount.
Yeah.
So the actual repairs were $14,000 on an $8,000 car.
Okay.
All right, well, she isn't here to argue about it. She was personally served by Sergeant Moores. She did acknowledge responsibility for the accident by pleading to the ticket. And your testimony under oath is you were informed by your insurance company that she did not have insurance, making her liability the maximum under the mini-tort under the statute. I used this case as an example several times last week. I have lots of no insurance criminal cases. It's a misdemeanor punishable by up to a year in jail to drive with no insurance. She presented some sort of evidence to the police officer who reported that she had insurance. Apparently, according to your testimony, that insurance was not in effect. She's not here to argue about it. So she owes you $7,000 plus $83.50 in costs and $56.15 in service fees, for a total of $7,139 by default. Now, getting this judgment is the easy part. Getting the money is the hard part. If she's not paid within 30 days, you can start collections. The order is inconsistent. Actually, is due within 21 days. If she's not paid within 21 days, you can do a discovery subpoena to compel her to come to court. So she doesn't have to come to this trial. It's not like a criminal case. If you don't show up at a criminal case, you're in contempt of court. If you don't show up in a civil case, you just automatically lose. That's what just happened. Now, she owes you this amount of money, theoretically, to be paid within 30 days. That's unlikely that she's going to write you a check for $7,100. What do we got? Oh, so after 21 days, you can come to the court and ask for a discovery subpoena. That would compel her to come to court and answer questions about her ability to pay on this debt. So it's going to be difficult to collect. I've had several of these where the plaintiffs are trying to collect on a substantial debt. She was personally served here in St. Joseph County. Let me see where that was. By Sergeant Morse at the same address, the Orange Street address that you have. All right, if you go out to the counter, the clerk will give you a copy of that order. and you're free to go. She can also give you some additional advice in just a minute about the discovery subpoena. All right, you're good to go, Mr. Rink. Good luck.
I have a question,
You
Your
got
Honor.
your judge. Getting the money will be another thing, but thank you.
All right, thank you, Your Honor. Have a good day.
Thank you. Oops. All right, our next case, the defendant is here, the plaintiff is not. In the last case, the plaintiff showed up and the defendant did not appear. In this case, there's no one here on behalf of Magic Capital LLC. Ms. Gentz, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right, you started to give me a little information. Let me get into this case. I was a little confused, but who is Magic Capital LLC?
So that's gonna be Carl Thornton and Brent Frank. I did most of my talking through Brent Frank though.
All right, well, you apparently rented this property in the village of Colon at 115 and a half East State Street. Where's this apartment located?
Downtown Colon, across from Curly's or 5 Star.
In what building?
It's above where, do you know where the pallet store is at or was at?
Okay, it's above one of the downtown stores?
Yeah.
All right, well, it looked like a nice unit in the pictures. You got a letter of demand from Attorney Deborah Davis of Colon back in, what's the date on that? April 5th.
It was April 18th, 2024 that it was sent out.
All right, well, it's dated, okay.
Oh, wait,
Anyway,
yes. April 15th, sorry.
I believe Miss Davis was in private practice at that point. She had worked in the prosecutor's office. Then she wasn't there, and now, as you know, she's been elected as prosecutor, and she'll start January 1st. At any rate, she wrote this letter saying that you owed $3,493.32. They kept a $900 security deposit, demanding $2,593 and an estimated cost of $4,000 cleaning fee. So I think it turned out to be more like $300. Anyway, did you pay anything after that letter?
I replied to that letter after going through the Michigan law, which I have it. I have the letter. I could read it to you if you would like.
Well, I don't need to. I'm just they aren't here.
Yeah.
And so they.
I think my biggest thing for me was, according to Michigan law, they had 30 days after vacancy to get like the pictures to me or a list of itemized damages, and they never did that. I still have yet to see the pictures until August 28th. So according to Michigan,
and I don't have privy to exactly what happened. When you leave, you're supposed to go through an inventory checklist with the landlords. I'm sure that didn't happen here. And you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. Here is somebody late to the party. Let's see who this is.
Judge, am I on mute?
Well, you're on, I have a telephone number only. Who am I speaking with?
This is Brent Frank from Magic Capital LLC. I apologize. I was having a hard time getting in. Case 24-1227 ST-1.
I'm very familiar with the case. I was just about to grant a default judgment and award you $0. You didn't even show up on time for your own hearing, and you're here only by telephone, which is not ideal. If I hadn't dinked around with Miss Gentz trying to get a little information to see whether anybody would show up, we'd been done already. Do you have the ability to come in by Zoom?
Yes, I'll try to do that right now.
All right.
I apologize. I was having troubles with my computer. I'm traveling. I can get in right now. Couldn't get in, so that's why I was called in. My computer, unfortunately, having issues, but I'm loading it now. Connecting, the computer's having a little bit of issues, but it says it's connecting.
Do you have an email address?
Yes. Oh, it's connected right now. There we go.
Yeah, there it is. All right, the time to practice this isn't 20 minutes after the hearing started.
I apologize, Judge. Absolutely.
All right, so you look like you're in a harbor in Caribbean somewhere, but all right. You're here on a small claims matter. You've sued for money damages, the amount of $2,893.
Correct.
In a small claims case. The rules are different than general civil court. In small claims, the damages are limited to $7,000. There is no formal record being made. There is no appeal from small claims. Neither side is allowed to have an attorney to represent them in the matter. And there is no appeal from small claims. Once we begin, all decisions here are final. So there was a demand from Deborah Davis, who was representing your LLC at that time, and we were referring to that document. first thing I need to do is place you under oath. Could you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right. I had asked Miss Gentz a few questions. She is under oath, and she was trying to explain some background here. There was a lease, and under the Landlord-Tenant Relationship Act, sometimes known as the security deposit law, when a tenant vacates, they're supposed to turn in their keys and give their forwarding address in writing within 4 days of their vacating the property. And I just started to ask that question when your phone number showed up. So, Ms. Gentz, you said that you left the apartment on what date?
March 10th.
Did you turn in your keys and give your forwarding address?
I turned in my key, but I did not give the forwarding address.
All right. Then we aren't in a supplemental money damage hearing. We're in a small claims hearing, so the rules are more relaxed. So let's go back to Ms. Davis's demand letter. They are demanding March rent of $900, March utilities of $130.43, and a late fee of $40 for March. They did not charge you for anything after March. Well, let's start at the beginning. Mr. Frank, what's your position with Magic Capital LLC?
I'm a member of the LLC, sir.
All right. In general civil court, you could not appear on behalf of an LLC, but you can in small claims court if you're a member of the limited liability corporation. All right. So this was December, January, February, and March's rent. Is that correct?
January, February, and March rent.
Oh, just December utilities. Sorry, January,
Correct.
February, March rent.
Correct.
December utilities of $151.92, a late fee for December, January $900 rent, February $900 rent, March $900 rent. Now the lease that she had required her to pay the utilities?
Correct.
Now, in the pictures that were attached to the complaint, this place looks pretty clean. I've certainly seen a lot worse. But you hired a company to come in and clean this for $300?
Correct. Correct.
Tell me about that.
The refrigerator was a mess, as you can see from the pictures. There were items left behind, and generally the apartment was in disarray and not clean, not something we could rent.
This was cleaner than about 99% of the apartments that I see. Everything was gone from the refrigerator. It looked a little dirty. The shower looked like it had been clean, but not immaculate. Everything was mostly removed, but there's a bunch of junk. Looks like a fire waiting to start, stacked up by the water heater, and a few other items. There is some expectation there would be normal cleaning after the completion of a tenancy. And then you did apply the security deposit to the amount owed, and that's how you came up with $2,983,932.
Yes, Your Honor.
All right, Ms. Gentz, what's your side of the story.
So as far as the utilities go, all winter I didn't have any heat. The heater didn't work. So I wholeheartedly believed that I was being charged too much for utilities, and I never received a statement or anything listing exactly what was used. And in my response email to Debbie, I had asked for those and never got them back. When I did move in, I knew that the utilities were split between 3 different renters, I believe, but I don't understand how you would get the utilities for that. And as you can, I have all the utilities in front of me for what I had to pay. Just seeing the jump to winter when not having heat or anything, I didn't have AC in the summer, and those utilities are far lower. And then you go to winter, didn't have heat either, and those are obviously higher. I guess that I feel like I need to see the statements for those to believe that that's what I actually used, considering I didn't have any heat.
All right, well,
basically,
what was the source of heat in this apartment?
It was coming from the building below.
No, there's a furnace dedicated to this unit. It's in the basement, and the furnace works. Pipes didn't freeze.
After we had that big
All right, well, just a minute. When we say utilities, what is included in utilities?
On the lease in paragraph 6, it describes the utilities.
All right, let me look.
Sure.
Everything is electronic, and I have to scroll to find everything.
Page 4 of the lease.
I'm still trying to get to it.
Sure.
If I had a paper file, I could just flip to it. Utilities, water, sewer, natural gas, and electric are not included in the monthly rent. Tenant will be billed monthly in arrears for water, sewer, natural gas, electric utilities. All right, that doesn't seem at all very high for water, sewer, electric, and gas. Although they aren't broken down by how much is water, how much is gas, how much is sewer, they're just sort of lumped together.
Each month we sent a billing, and it broke down what the water, sewer, and gas were, and the utility costs.
Do you have that for those months?
I have the emails. I'd have to go back and find them, but every month we billed them, and they were paid up to the point where the rent wasn't being paid.
All right, so her contention is she had no heat. Your contention is that there was a furnace dedicated specifically to this unit, and she was billed only for the gas for her unit?
No, the gas is split with the first floor unit, and she pays, because the same gas line goes to that furnace and another furnace. First of all, the furnace works. There was heat. There were no issues with providing utilities. I never got an email saying that there was a problem with the utilities. Never had any issues with the utilities. We have a current tenant in there now, who's tested the furnace. It works fine. We haven't done anything since the prior tenant moved out. And what we do is we split it based on usage.
Okay. Again, I gotta click back up to the letter.
To my understanding, Attorney Davis never received a reply because there was never service.
Well, she said she sent Deborah a reply. I don't have a copy of it. I was looking for it.
I don't know how that would be, Your Honor, because she didn't accept service of the letters, and we had to have a process server.
Well, I received an email from Debbie and I replied to that email. I can check.
Right. I don't have that reply, but anyway, these utilities do not seem at all out of line. Now, January is high, 215.63. That was the only cold month we had last year. For heat, electric, water, and sewer, they aren't broken down, but they don't seem inordinate. And they seem to be season appropriate. December was 151. We had a mild December. We had a cold spell in January, 215. We had a mild February, 175, and we had a mild March, 130. So the utilities seem like they match my recollection of last winter. Why did you stop paying, Ms. Getz?
Well, I quit working my job at a very well-paying job at Abbott, and then I was only part-time at the job I have now, but now I'm full-time. And I just didn't have the money to pay.
Well, that's what I call a good, honest answer. I wish I heard more of those. But it explains why eventually you couldn't afford to stay there anymore.
Mm-hmm.
Neither party exactly complied with the Landlord-Tenant Relationship Act. There was no walkthrough of a inventory checklist. You sent the keys but didn't give your forwarding address. They attempted to send you this certified letter, which you didn't accept. The cleaning fee of $300 is not inordinate. The question with that is, there is a body of law under the landlord-tenant that the landlord should be responsible for any ordinary cleaning in effort to re-rent an apartment. For example, many of the apartment complexes, as soon as a tenant moves out, they just automatically clean everything, shampoo the carpets, sometimes they'll repaint, but with smaller landlords, it's not always that way. I'm gonna split that in half. But Ms. Gens, you owe this money. You owe the rent, you owe the utilities. You didn't have the ability to pay, there's nothing malicious about it. But I'm gonna split the cleaning fee in half. So that reduces their total by $150. So 2,893.32 minus 150 equals, oops, $2,743.32. If we add in our court costs of $83.65 and $56.55, it equals $140.20. $2,883.32. $352. As a rule, we give people a half an hour from the time to show up. They were 20 minutes late, but here promptly enough to take sworn testimony. Ms. Gentz, this judgment has entered and you're going to owe this money. Are you able to make some sort of installment payment on this? Like so much per month?
Yeah,
How much could you pay each month?
we could do 300 a month.
All right, is that acceptable to you, Mr. Frank?
Absolutely.
We're going to start that October 15th. All right, and you are at the Covey Road address?
Yes,
All right, and where's your new employer?
Glicks. I was working there at the same time as living at the apartment
Where's a Glitz?
in Sturgis.
Oh, I didn't realize there was one there. There was one in Three Rivers at one time. All right, I find after hearing that you owe $2,743.32 plus $140.20 in costs for a total of $2,883.52, payable at $300 per month starting October 15th to the Magic Capital Post Office box in Colon. I suggest that you use a certified check or money order or some sort of bank deposit. Don't do cash unless you get a receipt. If you want to pay it sooner, you can, but as long as you pay it that much, it'll get the matter paid off relatively quickly. All right, you'll each get a copy of this order. Thank you both. You're free to go on about your business.
Thank you, Judge.
Thank you.
All right. All right, that completes our long day. It looks like we have another long day tomorrow. I don't think Judge Patterson's going to be here tomorrow either. So I'll have his morning docket and afternoon docket as well as mine. But we'll make it work, just like we